One of the four strategies end up with TikTok going away. Three of the four strategies end up with TikTok actually staying. So there's a lot of options available. I think there's 75% chance that we actually survive. Time for the TikTok recap. So you're ready to hear me recap what happened at the Supreme Court oral arguments Friday, January 10th. I watch as an attorney the oral arguments in the Supreme Court twice, so you don't have to, and to recap the briefs and all the parties involved and why I think TikTok will stay, how there's a 3 in 4 chance that we can survive all of this despite what you're hearing about it being over. Stay tuned for this video. And this is actually your animated non-legalese version, because a lot of people who are talking about this are either too legally or just didn't listen and watch and do all of the things that I did, so they may not give you the full context. So if you want a thorough context, stay tuned. So in this video, I'm going to summarize the main characters, the main arguments, why I think TikTok and how I think TikTok actually could survive this challenge, but it's really important that you watch all the way through. And I know some people struggle to just listen to someone talking. It's kind of like school all over again. However, I watched it twice. So that's 5 hours plus reviewing all the briefs, so you don't have to. I'm going to mention when I do the recap buzzwords and terminology that will only make sense if you listen to it while I'm going through explanation. If you rush ahead to the end and you're going to see a reference to a word or term, you're like, what is she talking about? It's not going to make sense. So that's just my disclaimer. So let's get started. We're going to start a little bit with the background first. And if I'm new here really quick, my name is JJ Gatt. I'm a content creator, attorney. I've done regulatory law before. I was an FCC attorney. I've written a brief at the United States Supreme Court before and presented briefs before the 10th Circuit, the 5th Circuit, the 3rd Circuit. Went to Catholic University and Georgetown University Law Center. I have 2 law degrees. Anyway, let's get started. How did we get here in the first place? When Donald Trump was president in 2019, you may not know, he had suspicious about China and he was concerned about TikTok. So on his own, unilaterally, Donald Trump decided that he was going to try to ban TikTok using an executive action. Now, this is also a great exercise in understanding a recap of civics United States government law, and our 3 branches of government are implicated here. As we all know, this case is before the United States Supreme Court, which is a judiciary, and the Donald Trump who did that is an executive. And what we have now is a challenge to a law that was passed by Congress, which is the legislature. As you may not know, the executive branch executes the law. They don't make law. They do kind of make policies and procedures. So, for example, the FCC have rules, the Department of Education have rules, the EPA, Environmental Protection Agency, has rules. The various different agencies all have rules and policies under executive. But in terms of making a law that impacts broadly, like ban an entire app, that's not something the executive does. So, as you can imagine, when Donald Trump tried to ban it, it was immediately challenged, and so it remained in the judicial process of being challenged until he went out of office. And that's the issue with Donald Trump. I could talk about it another time. He thinks he can unilaterally do things. He overreaches. I don't want to get into that. His authority, and it gets challenged, and it ends up being, and nothing happens. And that's what happened. When Joe Biden came into office, new sheriff in town. So what Joe Biden decided to do, rather than he suspended Donald Trump's ban, and he says, rather than just ban TikTok, let's try to research and develop a body of evidence and see if we can come up with something. But let's do the work. The benefits of doing that way that Joe Biden wanted to do is because then you develop a record. That way you have more meat, more basis, more weight to your decision. So there is an interagency called the Council on Foreign Investment in the United States. It's made of people in different agencies. They get together, and this is not new. Whenever there's a foreign investment in the United States, and they work with the parties, and they sometimes come up with a resolution. Maybe they say, it's the national security concerns are too great. We're going to ban you, like they did with Grindr, that was Chinese owned. Council of Foreign Investment in the United States says the national security concerns with their being owned by China is too great. We think you should divest. Sure, they did it. Or they can come up with a national security agreement. And so they were in the process of doing that in 2021. Everything was going good until 2022. If that was you guys who may or may not remember, there were a flurry of Chinese spy incidents that got discovered. It caught the attention of the United States military. The United States military started to ban the use of TikTok on devices, on soldiers' devices, civilian and active. And then also a lot of the state governments started to say, okay, something's going on. We don't like this. State governments across the United States started to ban TikTok's use on the government phones. So it started to become a thing. So Joe Biden was waiting for the Council on Foreign Investment to do its job. And it was taking a little bit while. They were negotiating things. And it was looking like, you know what, we can't wait till you to finish. Wrap up what you have. Let us know. We're going to go ahead and try to just do something more drastic. November 2022, Donald Trump's pick for Secretary of State for his administration that's going to start on January 20th, Marco Rubio, along with a Republican member of the House, Mike Gallagher. Together, they wrote an op-ed in Washington Post saying why TikTok should be banned. So Donald Trump's future Secretary of State, Marco Rubio, started the process in Congress. And they was joined members of the Democrats and Republicans. They took the data they got from NSA and negotiations, all that stuff, and they came up with a comprehensive bill that they worked through in 2023. That final bill saying why they should ban TikTok in protection of national security concerns was passed by Congress, a bipartisan effort based on a thorough record on it was April 2024 last year. So that's something that has more weight, that can be, it's substantive compared to just an executive action someone like Donald Trump tried to do, just say, oh, we'll just ban it or we'll just keep it based on just a whim. So it's easy to get challenged because it's like a paper thin. It's based on really like just nothing, just my wishes, where you have this thorough record that Congress has established. So that is a challenge that TikTok had to try to overcome that. So what the first thing TikTok did was they filed a challenge asking that the D.C. Circuit Court of Appeals to do two things. One, to overrule the Congress's act, and then also to file an injunction, just mean like stop it, preliminary injunction, like stop it while we're like adjudicating this case. So those are two things that ByteDance and TikTok together asked the court. Now, the Court of Appeals says no. I'm going to go through what TikTok argued. TikTok made two constitutional arguments, one based on the First Amendment and the second one based on the Fifth Amendment Equal Protection Clause, meaning that the government can't treat one party different than the other. It's like we all have to be treated equally. And it's really important that you pay attention that TikTok did a First Amendment argument based on the fact that TikTok Incorporated is a U.S.-based entity. So they're saying the United States government is infringing upon the rights of a corporation. Now we're going to go back to Citizens United. That's another thing. But anyway, and even though TikTok's parent company is ByteDance, which is Chinese, TikTok Inc. is American. So that's really important. They're saying that the United States government is infringing upon its content. It's content-based. Put the pin in that. Content-based is really important because in the United States, before we can bridge up someone from speaking, the highest scrutiny for content is strict scrutiny, meaning that if the government's going to do something, it has to be narrowly tailored, so it doesn't burden something, narrowly tailored, like it has to be super, super quick to meet the compelling state interest. So if it's a balance, like the First Amendment is paramount. In order for you to restrict on speech, if you have another interest, a compelling interest, you can do it, but you can have to do it so much so that you restrict speech to the least possible way. That is the thing. Kind of help you through figuring out the difference. It's like if you know in the criminal context, you've heard the word beyond the reasonable doubt. So if someone's being accused of a crime like first-degree murder, for example, before you can put somebody in jail for something like that, which is a serious crime, you have to show, the government has to show all the evidence, and it has to be beyond the reasonable doubt that they did it, compared to other ones like reasonable suspicion or like intermediate levels of scrutiny there's below, where you just have to show like it looks more likely not that they did it. You know what I mean? So that's the criminal context. In the civil context, strict scrutiny is something that's applied when the government is infringing content, and that's really important for later on. I'm going to tell you about that. And so that is TikTok's argument here. And so they say not only is the government trying to restrict the content, and the content is stopping us from associating with ByteDance, our algorithm, getting access to ByteDance algorithm. Now here's where the technical stuff comes into place. According to the documents, TikTok Inc. has said that ByteDance has a source code that includes a lot of different parts, and then they have a series of engineers all based in China. They create this phenomenal algorithm, this algorithm that's like so good that keeps you guys on it. All the other social media apps want this algorithm. So TikTok Inc. says in order to get access to this Chinese algorithms, the Chinese ByteDance distributes out to TikTok Canada and TikTok South Africa and TikTok France and TikTok, to all the different subsidiaries. They exchange the data and they get access to this powerful algorithms. So by the government telling them that they have to ban it, so whether the ban is like saying shut down altogether or telling ByteDance to divest, it's equivalent to a ban. It's infringing upon their speech, and in speech of the creators. So a separate set of content creators, actually was two. One was some conservative creators that said that there's no other platform, especially at that time, the Facebook, though it's shifted, Facebook, all those other platforms are liberal, left-leaning liberal, and so they really can't really communicate and meet and exchange ideas on those other platforms. The TikTok is the only platform that allows their conservative voice to be heard. And there was another set of creators that just says TikTok is a way for them to make money. They engage in ideas, and it's unlike all these other platforms. So together, TikTok's paying for the attorneys for these they consolidate all the creators into one. They're a class, and their arguments are that they need to be able to communicate, and by government shutting down TikTok, it's stopping them from speaking, and that's it. And they also say that they also contract and have brand deals with other foreign companies, and and that's not unfamiliar. And the restrictive way, with the least restrictive way the government should have done it, rather than ban TikTok altogether, they could have just had a language. Like when you open up app, it says, hey, you look this app, you're at risk. The Chinese government may or may not watch your stuff and may not track you, and they may come after you later on. So they said that was the more restrictive way that the government could have done it outside of a ban. I hope that's clear. So the government's argument was that this has nothing to do with speech. They were saying this is a strictly content neutral, and that's a really important word or term, content neutral. And the government has the right to restrict speech on a neutral basis. For example, if you wanted to protest, the government couldn't say, we don't like your speech, so you can't protest that cause. But they do have the right to say time, place, and manner, meaning that we can tell you, you need to get a permit. You need to make sure you have liability insurance in case something happens. We have to, put it on our calendar. So we have the right to tell you how you can speak. And they said that's more like this. This is content neutral. This has nothing to do with First Amendment. This is all about national security concerns. And what the government says is there is some data and information they got while TikTok was negotiating with the United States Council on Foreign Investment in the U.S. and trying to come up with a national security agreement, that there were some sort of issues. In 2022, around the same time, like I said, that the balloons were being found, when the state governments were like banning TikTok and the military was banning it, and Marco Rubio did this huge op-ed piece saying we need to ban it. There was reports that 4 ByteDance employees were tracking the geolocational data of American journalists, from a couple of American journalists, to see if they were at the same time around some Chinese dissidents or citizens they believe were leaking information to these journalists. So they were looking at the geolocational data of American journalists. The Financial Times and I think Fortune magazine said there were some as well. So all of that caused a bunch of alarm. And the government argued that, I'm going to talk about later on during the oral arguments, that was one of the main concerns. Like, they actually have evidence. There's some other information that they discovered, but the government sealed it because for national security concern, they didn't want to make that public. The argument at the Supreme Court was just on the publicly available information. And there's also some proprietary information related to how TikTok's algorithms and they work that's also under seal. But if you look at all that stuff, the government's essentially saying we had a really great national security concern based on what we think that they're already doing, that they have access. Now, the key term that you need to know is covert content moderation. So the government said they have 2 concerns. One is the concern that the excessive amount of data that TikTok has of 172 million people could be used for espionage and for blackmail. Knowing that there are a lot of young people there, at some point the young people who are on TikTok in the future, let's say they want to work for the FBI or they want to work for the military, TikTok having all this data could use that data to blackmail those kids in the future. And that's a danger. And the second, that just access to all this data could be used to manipulate Americans' thinking using covert content manipulation or content moderation. And that risk is something that they said we need to remove, and we need to cut off a backdoor access. So that is the argument of the American government. Even though you might have seen TikTok and other people say that there's no risk, it's all speculative. They're all saying that what could happen, but they don't have any proof. So the American government is like, no, we do have some proof, and we need to be looking out for our national security. And ByteDance is subject, as a Chinese company, to making its assets, including its data access to its subsidiary, available to the national security interests of the Chinese government. So the People Republic of China has a law that says if you're a private company in China, you, at the whim of the Chinese government, must give up something that you have in interest of our national security. So why can China protect their national security and can't? So that's something that those of you who kind of like, it's not a national security thing, you guys really need to think about. Like, that's serious. Like, what, you don't see the unfairness of that. So that's why I'm just like, think about that. So they're saying that's why, so they can secure it, we should be able to secure it. So it's really a Chinese company and it's beholden to the Chinese government. And because of that, and China is what's called an adversarial nation. We have allies and adversarial. So while we work in coordination with China, for the most part, it's still adversary in that they spy on us. I'm assuming we spy on them. And, we're in competition. And there's just a lot of like, in the Ukraine war, for example, China helped Russia, we helped Ukraine. So talks about adversary compared to allies. Mexico's an ally, Canada's an ally. That's Greenland, Denmark, which owns Greenland, is an ally. That's why we were concerned that Donald Trump, for the second time coming into power, is trying to like bust up our relationship with allies. Who does that benefit? I don't know who that benefits, but he did that in his first term. In this term, he's agitating all of the allies. Panama, the Dutch people who own Greenland, Canada, Mexico, just irritating people. He's a freaking irritating person. But I digress. So that is what we have here. There's a true national security concern based on all those reasons. And for that reason, they felt like the act should be upheld. It was created by a bipartisan effort. There's a huge record to support it. And there's no reason for the courts to butt in when you have all that data. It's two bodies of the government coming into play here to create this. So there's not really space for the judiciary to come in and supplant and substitute something that's already done, really, for the most part. So the Court of Appeals said, yeah, we agree with you that they did agree with TikTok that this is a First Amendment issue. So that's a win for TikTok, because the government was saying this has nothing to do with the First Amendment. This is purely content neutral. But they said despite that, the government's national security concerns supersede or really were concerning, and what they did in terms of asking for a ban, whether via like a direct ban or through divestiture, was the narrowly tailored way of meeting this national security concern. And that was that. Fifth Amendment argument that they're treating them differently compared to other platforms. And this is where TikTok threw other apps like Shein and Temu under the bus, because they say, listen, look at here. Temu and Shein are Chinese companies, and they're collecting data. They're doing all this stuff, and it's e-commerce. So they not only have your data, they got your credit card numbers, and they're Chinese as well. So this is under-inclusive. This law just targets us. So to say it's just about data security or national security concern is not true, because if that was the case, you would not just be just against TikTok, it would be against all the companies, but it's just about us. So that's where the content is. You're singling this out as for Fifth Amendment argument. ByteDance doesn't have Fifth Amendment rights. They don't have First Amendment rights. And that's going to be important when I talk about the oral arguments in the distinction, because this case is being brought by TikTok, which is the American company that's a subsidiary of ByteDance, which is the Chinese parent company. The two of them bringing this case together. And the fact that the TikTok really, really needs the Supreme Court and all of the justices and all the judges to agree that this is an abridgment of their First Amendment rights. They have to, and content, that's really important. They can't have the Supreme Court focusing on the fact that the parent is Chinese, it doesn't have any rights. They can't have the Supreme Court like trying to like dilute the content and sort of say, well, it's not really speech. And that's what they did in the oral arguments we're going to get out to later on. So anyway, so when they lost, they asked for when they lost, they asked the DC Circuit Court of Appeals, all right, fine, we're going to appeal to the Supreme Court. Can you at least issue a preliminary injunction? Because here's another thing. Here's another buzzword. 270 days. That's the clock that the Congress set in the law that says you have to divest or go dark in 270 days. They extended that 270 days by 90 days because of the United States presidential election. And the timing, I'm not quite sure if they did it on purpose, bumps up right the day before the next president gets inaugurated, they have to be banned. I don't know if they did that purposefully or if that's a coincidence. I'm not quite sure. But TikTok's argument during the Circuit Court of Appeals level, when they first took it to court, was like, the threat that the government says is imminent and they're concerned about isn't really real, because y'all gave us a 270 deadline and then y'all extended it by 90 days. And who's to say that during all this time that y'all waiting for us to divest and stuff like that, we're not collecting data and sharing it anyway? So is it really truly a threat? That was TikTok's argument. But of course, like I said, they got batted that down. The Supreme Court, when they asked the Court of Appeals to say, can you issue an injunction or stop it from acting while we go to the Supreme Court, the D.C. Circuit Court of Appeals says, no, we're not doing that. So they lost twice. Then they go to the Supreme Court and say, hey, Supreme Court, can you hear our case? This is really, really important. This really matter. It's 172 million Americans are on our platform. This is serious. You got to take this case. And not just that, please issue an administrative stay to stop this clock from ticking. Because the D.C. Circuit Court of Appeals said they're not going to stop the clock, and we need you to stop the clock. So the Supreme Court said, okay, we'll take the case. I didn't think they were going to take the case, but they did. Supreme Court said, all right, we're going to take the case. We're going to accelerate the briefing schedule. Normally, it's a long time. We're going to say, give us your briefs, all the sides, by December, and by January, give us your reply briefs. And we're going to hear the case on January 10th, 2025. We're not going to issue a stay. Depending on what we hear on January 10th, we'll quickly let you know whether or not we're going to actually do an administrative stay or not. So they filed the briefs and the reply briefs. For the most part, it was the same. The government, in response to TikTok asking for an administrative stay, said that actually there was no standard for the Supreme Court giving them a stay, meaning stopping the clock from ticking, because in order to get a stay, you have to show that more likely than not you're going to succeed on your merits. And there's no proof of that you're going to succeed on the merits. The other argument that was in the briefs that wasn't in the original Court of Appeals below was the argument that there's other least restrictive means of doing this, because now we're at the Supreme Court and now we're trying to save it. And so they're saying TikTok, with negotiations with the United States government, had a couple of alternatives. The two alternatives, one of them was a risk announcement, sort of like before you go on the platform, you get an alert or pop-up that says that you are at risk of potentially anything you say here could potentially be accessed by the Chinese government and used against you in the future. That's enough. Or two, that we can just separate the data. We can say that we're going to separate the data. Our data centers are in Virginia, and the person or the company, the entity that monitors and manages it is an American company, Oracle. And we have American shareholders, and we are an American company, and it's all America, so you shouldn't have to worry about that. That's a more least restrictive means. The creators, in their argument, said that also that they believe that the announcement is enough to abate the concerns from the government about national security, and that is a more least restrictive means. If we're applying the strict scrutiny standard, that a ban is too broad, and because it's content, before you infringe upon content, you have to do the least restrictive means, and a broad ban is too broad. So that was the argument. So the Supreme Court said we're only going to hear the First Amendment arguments, and so they issued those same arguments. They weren't alone. There were a lot of parties that filed what's called Friends of the Court briefs, the ACLU, different parties who have, feel like they want to say something. So they're not direct parties. They're just people who just have some thoughts. So all these people filed, most of the Friends of the Court briefs were in support of not banning TikTok. That's the background. Again, like I mentioned, those buzzwords that I mentioned throughout the summation, it's going to make sense later on when we just go through the arguments. Lawyers, the three parties that argued, excellent, seasoned Supreme Court constitutional law practitioners, excellent. Noel Francisco argued for TikTok. He was excellent. He was really, really good. Listen till you get a chance. The Solicitor General is Elizabeth Prologar. Excellent, sharp as a whip. And then finally, Jeffrey Fisher for the creators. All really great job. Now I'm going to tell you the clapback response. Though they gave each attorneys adequate time. I think the creators had the least amount of time, and they pushed back against all of them. They all did a wonderful job. The TikTok attorney got more pushback, more questions from the justices. So I'm going to do them last. First, on top of the creators. The pushback the creators got was the justices, for the most part, saying the national security concern is serious. Now, while we realize you guys have interest, your free speech rights and what you all say, Justice Sotomayor, I think, asked Jeffrey Fisher, is there any other platform? The thing about it is there's this platform has 172 million users, and it's not just about the access to the data, it's accessing the data of their contacts as well. So you don't think that that's a big concern, national security concern, to which Jeffrey Fisher said, yeah, that's true, but there are other organizations. And they said that we have, as content creators, have the right to reach out to other foreign entities. Like we do like deals with other companies. And so that's fine. There's a more least restrictive way is going to infringe upon our First Amendment rights. But that was the biggest pushback, them saying that you don't really have the right. The government has the right to restrict speech as to the Federal Communications Commission. They can stop you from entering trade agreements with like countries that are embargoed. You can't go to Cuba, stuff like that. So your right to speech isn't really being infringed because you have other alternatives. Just because you like it doesn't mean you have to. Like, we have the right to do it. So that was the argument, the pushback against for Jeffrey Fisher against the creators. Now, the pushback against the government was a little bit different. And it was pushback, but essentially they asked Justice Kagan actually said, like, what's the big secret? We all know by now that China is behind TikTok. The United States government pushed back against the justices, asking them if they could enter an agreement that's lesser restrictive than requiring a ban, and to which Parlagar said that no, we were told by ByteDance that in TikTok that it was virtually impossible, that their offer that have us monitor their data is off the books because they said even Oracle, which is the company that owns the data, would have a tough time managing the fast-moving parts and the fast-moving back and forth data exchange between TikTok USA and ByteDance. And for that reason, we cannot trust them because we've had evidence that they've actually monitored and surveilled United States citizens, United States journalists. And because of that, the only least restrictive ways to meet our interest is to actually have them just divest altogether. And so it's a separate algorithm. They can operate the separate algorithm on their own. No one's restricting their speech. And it's not a speech issue. And even if we do apply the strict scrutiny standards, it would meet it because the compelling needs of stopping access, a backdoor access to Chinese government to all 172 million Americans and the people who are in their contact list is severe, given what we already know, given the information. Go look at the information in the docket, that what they can and can't do. This is adversarial nation. This is not real speech. Yeah, we can't do it. And what was very critical and crucial is that she said that this is just a game of chicken. ByteDance was hoping that we would blink first, hoping that the executive would back down, hoping that Congress would not actually enact this law, and hoping that you, the judiciary, would not uphold the law. And they're not taking it seriously. Now that we've gotten to this stage where they've lost a couple of below, and the writing is on the wall. It's not irreversible. It's not irrevocable, meaning that they could actually start seriously considering the offers that have been put to the table from different entities to buy them. And now they can do that, where they didn't do that before. The clap back from No Francisco to that was interesting because he got so more animated. He was just like, well, if the concern was data, non-sensitive data, then we could put that on the table. But anyway, I'm going to discuss that later. I thought that was interesting how animated he got in replies. You got to go listen to that. It's towards the end. So if you catch it online, go towards the end and see his clapback. It was a real good clapback. Anyway, so he had a challenge because what essentially they had to have the justices agree with was, one, that this is content-based, like strict content-based communication that's being challenged and being stopped here. And that's hard because it's a company, first of all, and then they're really talking about the algorithm for the most part. And then they're also talking about not just the algorithm, they wanted access to the algorithm. So when people think about speech, they think about stopping somebody from arguing on behalf of Palestine. That's like speech. No one's stopping them from doing that. They're being stopped from is being able to communicate with Chinese owned company ByteDance, and they're exerting their First Amendment rights based on that. And the other thing, the elephant in the room is that they are owned by the parent company is a Chinese company. So that's another thing. And that's what happened when they went to the Supreme Court. That was the arguments they got. They got a lot of pushback. Noel Francisco made a lot of concessions. He'd already made them on paper, but to make them in front of the judges, it was kind of like, oh yeah. But he did a good job. So the So again, let's do a recap of the various different members of the court. So if you don't know their political leanings, it shouldn't matter, but it does. So let's go through that first. There are 9 justices. There are 3 left-leaning liberal justices. So that's Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson. On the right side, the extreme right, you have Judge Clarence Thomas. You have Judge Samuel Alito. During this case, a lot of times Samuel Alito brought up Donald Trump, like, Donald Trump's going to save us. Like, get out of here. Then you have the Chief Justice Roberts, who is principled because he is the one that actually saved the Obamacare. Like, he was like the vote to save Obamacare. He interpreted something that helped Obamacare. So yay for him. And also him, along with Amy Coney Barrett, another Trump appointee as a nominee, went along with these 3 to deny Donald Trump's request to have them save him from being sentenced. And so, yeah, that tells you something. Amy Coney Barrett actually has popped up as sort of like a maverick. She's independent. She doesn't always go along with the right side. Who's always going to go along together? Gorsuch, who was a Trump appointee, decided to join Alito and the Thomas with the extreme right, conservative, pro-Trump sort of leaning. Kavanaugh, he deviates once in a while. So he's kind of like you just never know with him. So that's the side. So all of them had questions that they peppered, which challenged TikTok's assertion that this is really a content issue, and please ignore the fact that we're a ByteDance. And the first, Justice Thomas was like, man, what's the speech here? What's the speech? There ain't no speech. You're talking about an algorithm. They were like, okay, yeah, but it's the algorithm. So they conceded. With Thomas went in the concede, but they conceded in paper, but the concede in front of them is like a different thing. Justice Roberts was like, okay, so you want us to ignore the fact that this is a Chinese company? Because we can't ignore that. Is that what you're asking? They were like, nah, don't ignore that. But the fact of the matter is we're still an American company. We're American investors. Our data center is America. We service all the America. We're an American company. Like, that's incidental, but they're still stopping us, our speech, from wanting to communicate with the best algorithm in the world. Y'all are stopping us. So that was the second concession. But he, like again, Francisco clapped back really great. Justice Alito, Mr. Pro-Trump, he asked some questions. Kavanaugh got Francisco to concede that it's a risk. Like, you know there's a risk. You have all these kids, they're young now, but at some point they're going to be working for the National Security Administration or the FBI, CIA, and the Chinese government is going to have all this potential information they can use to blackmail them, to to espionage or spy on them. That's a risk. And Francisco's like, yeah, it's a risk. However, despite that risk, there's more narrow ways to deal with that risk than just shutting us down and banning us. Neil Gorsuch got them to concede, or he already conceded, kind of like to bring up the point that the data security is a concern, right? Yeah, the data security is a concern, the exchange of data. But the way Francisco clapped back with that is that he said, yeah, however, if it was strictly a data security thing, they wouldn't have been so under-inclusive. They would include Temu. They would include Temu and Shein because they're collecting data night and day, and they're a Chinese company. What's up with that? So that was a really great clapback. Like, okay, yeah. And ACB, so talking about the, trying to get them to like dumb down the type of content, Amy Coney Barrett was like, isn't the speech really the algorithm here? And again, Francisco was like, yeah, the speech is the algorithm. And so she was kind of getting at and the algorithm, so you want to be able to have access to this Chinese company's algorithm. This Chinese company does not really owed any First Amendment right or any Fifth Amendment right or any rights. Really, is that what you're asking for? Yeah. Essentially, that's what I'm asking for. And Sotomayor was like, and what's the difference between this company that's 177 million Americans that you have access to? Like, that's a big deal. To which, again, they threw Shane under the bus and say, yeah, however, you got these other companies that are doing almost the same thing that the Chinese, but what about them? What about them? So great clap back. And finally, Justice Kagan actually said, well, we're going to implement this individual incident. Oh, and Kagan was like, and again, hammering it down, like, okay, it's incidental. The First Amendment thing is kind of hard to get because it's incidental. You can always continue algorithms. You can always, no one's stopping speech. The fact that your speech is being stopped because you want to be associated with ByteDance, isn't that an incidental infringement? It's not a direct speech. It's not really speech. It'll concede with that. And then finally, Justice Ketanji Brown Jackson said, isn't this really about association? Like, you want to be associated with the company that has the best algorithm in the world. Isn't that really your concern here? It is a concern. He's like, yeah, but. So because of all of those arguments, it looking like I don't know. I'm not quite sure, but I did see an out in all of this, and those are the arguments again. Again, go back and look at it, especially in the reply. The buttons were really, really good. At the end of the day, and in the reply, Francisco's like, they didn't say that they were willing or interested in us just walling off data that is non-sensitive data, or they just said something about the actual sensitive data. But if their concern is non-sensitive data, we can wall that off. We can wall off the data. We can do the risk assessment. We can do all that stuff. Let's get back on let's work this out. And the government during their argument was like, they never mentioned that they could actually wall off. They made it seem like there wasn't wall off. So at the end of the day, I think it is possible. It's just to be burdensome. It'll take a lot of time, and it may be two different algorithms, but how I see it working out and what I thought that I can propose, and I'm not a business person, I don't know, but this is what I was thinking, maybe a solution for all sides, is that when they sell it, they sell the assets, resources, but as to algorithms, they could just make it 50% ownership. That way it's not technically a sale, so they meet the concerns of the Chinese government selling IP, because it's not selling, we're just like partnering. And that also meets the concerns of the United States government wanting to be separated, because if TikTok is saying that there's data flow back and forth, and we need the constant data flow in order to exchange. But if it's owned equally, right, then to the extent that there's any covert, this is a buzzword, covert content manipulation, and that's a big concern. The fact that the equal ownership would be able to stop that, or would ever have to some say, because they can't just, I'm assuming they can't just stop. If they're going to do some covert content manipulation, there has to be some sort of discussion there. It can't be backdoor. So equal owner, the partner, 50% owner, would know and be able to alert the government and stop that. I'm thinking that would be the solution, and that would save it all, because as the government said, it's not irrevocable. So again, the options here for the Supreme Court are four. One, they could overrule the Congress. I doubt they do that, because again, this was a bipartisan effort, a thorough bill that took about a year to put together, and that would be a big overreach. And I don't think there's appetite based on the questions that were asked and answered by the other justices. I don't think they're willing to go that far and overrule that. I don't think that's really be activist, and it's like supplant the interests of two branches of government, because it's executive. Even with Trump coming in, they already acknowledged that whatever Trump does is like will be challenged. It may not be challenged because it's a little different this time. It's different posture. Maybe he has less challenge because, like I said, most of the friends of the court briefs that were submitted in favor of ByteDance. So the only person to challenge will come from perhaps the government, perhaps the other side, the national security side. But anyway, I digress. They could actually affirm it. They could actually overrule the courts below and determine that the statute was not narrowly tailored enough, and it should have been more narrowly tailored, and they should consider other alternatives. That's the best scenario for TikTok. I don't know if that's going to happen. The second good scenario for TikTok is they can say, well, we're doing administrative stay, even though you may not win it, and just while we wait for the next administrator to come in, and we let the parties negotiate the terms and see if you can come up with something that's better. So we can do that. That's the second alternative. The third alternative, they can just say, no, we agree, we're going to overrule it and ban it and shut it down. The fourth alternative is they can say we're going to overrule it and ban it, shut it down. But one of them, the TikTok says, forget it, we're out, we're taking our ball, going home. The other one is the TikTok says, all right, fine, whatever, we'll go ahead and do what we think we could do. We'll start negotiating, accelerating discussions with some of the people who've already said that they will actually negotiate with us. So that's the fourth and final option that they can have. So again, 3 of the 4 options save it. They overrule the ban, and then it stays. Issue a stay, buys TikTok time. They affirm the ban, but TikTok say, all right, fine, we'll negotiate. Or they affirm the ban and TikTok say, forget it, we're just going to go home. So one of the 4 strategies end up with TikTok going away. 3 of the 4 strategies end up with TikTok actually staying. So there's a lot of options available. I think there's 75% chance that it survives. That's just my opinions. That's my thoughts. It's a freebie. So I hope that was helpful. It was super long. Thank you for sitting through all of this. I have noise in the background, but you got to ignore the noise in the background. I hope that was helpful for you guys. And if you have any more questions, ask below. It was longer than I wanted to be, but that's okay. Because again, I wanted to be thorough and over inclusive. And again, even though it's long, it's 30 minutes, you could have sat through 2.5 hours times 2 or 3 times, because it's kind of confusing. Like I had to do a couple of times to make sure I got all the issues, and you had a lot of briefs to read. So I saved you some time. So if you're interested in that sort of content, stay tuned to this account, to this channel. I do more legal analysis, information like this. I'm going to be following up on this after this, beyond this case. And if you're watching this on any one of my social platforms, what I do is help people prepare for the second Trump administration, particularly those people who are in his crosshairs, the federal government, undocumented workers and their friends and families and allies, and marginalized communities, people who don't want like anything that Donald Trump stands for. I'm your girl. So if you're pro-Trump, I hope that was helpful for you. And thank you for watching. You can go someplace else because I don't need your trouble here. Anyway, that's it. Thanks so much. Bye.